So picture this. It is June 1942. In Long Island, New York, one team of German spies is dispatched from a U-boat. In Ponte Vedra Beach, Florida, another team of German spies is dispatched from a U-boat. The landings don't go exactly perfectly. However, the leader of Team 1, the Long Island, New York team, named George Dash, pretty immediately defects and tells the FBI every other member of the spy team. What happens? I'm Brian McCann, and this week in American legal history, July 31st, 1942, the United States Supreme Court decides Ex Parte Quirin after a special session of the U.S. Supreme Court. Now, I'll take a step back in time to where the American public was in 1942. Pearl Harbor had just been attacked by Japan. Germany was seemingly invincible. It had run roughshod over Europe. And there was real fear in America that Germans could attack the United States, especially because Japan just had. Factories were ramping up production of everything from tanks to boats to aircraft. So the public was on high alert. It was at this point that Germany cooked up Operation Pastorius. They selected 8 men. 4 were going to go to New York. 4 were going to go to Florida. The point was they were going to land on the beaches on a small craft, integrate into the American public, and basically sabotage. Everything from factories to railroads to manufacturing plants to bridges to aluminum production to oil production. The purpose being to stop the Americans' ability to fight the war. But then what happened was it fell apart pretty much immediately. George Dash, one of the leaders of the New York operation, turned himself into the FBI. When he called the FBI, they didn't believe that it was really a Nazi spy calling to turn himself in. However, once Dash convinced the FBI that he really was a Nazi spy here to do sabotage, they finally picked him up and arrested him. What happened next changed legal history forever. So you have 8 Nazi spies arrested on American soil. The question is, how should they be tried? Should they be tried in a military tribunal, or should they be tried in the civilian court system? President Roosevelt felt very strongly these men should be tried in a military tribunal. Military tribunals operate very differently than civilian court systems. So, for instance, the rules of evidence, the appellate rules, what can be brought in, everything is much different. And generally, if you were a defendant, you would rather have the civilian system than a military tribunal. Because remember, the Constitution grants rights to civilian courts. That's how you get the full rights of the Constitution. It does not grant those same rights to enemy combatants in a military tribunal. What happened next is the Nazi spies and their lawyers argued they should be tried in civilian court, and the United States argued that they should absolutely not be tried in civilian court and they should be tried under a military tribunal. So here's the question the Supreme Court was tasked with answering. If enemy combatants, and these were Nazi spies, are caught inside the United States and they're not in uniform, does that mean they're entitled to the civilian protections in a civilian court system? Or can they be tried as enemy combatants? Remember, contemplated prior to this was really enemy combatants on a foreign battlefield wearing a uniform, not enemy combatants in the United States not wearing a uniform. This was truly untreaded ground for the United States Supreme Court to look at. So, on July 31st, 1942, the Supreme Court acted. Court distinguished between enemy prisoners of war and unlawful enemy combatants. According to the court, individuals who secretly entered the United States during a war to commit acts of sabotage were indeed unlawful enemy combatants. Therefore, They were not entitled to civilian court and were indeed allowed to be tried under military tribunal, even though it was inside the United States and they were not in uniform. So basically what the court said was there are two categories of enemy combatants, lawful and unlawful. An example of a lawful enemy combatant is a combatant in uniform on a battlefield. So in this case, that would be the European battlefield. A combatant who is under the Geneva Convention, announces himself, name, rank, serial number, is wearing a uniform. These would be unlawful enemy combatants because this was not taking place on a battlefield. This was designed to destroy civilian infrastructure, and it was enemy combatants who were here unlawfully, not in uniform, and who intended to do great harm. So, how did this end up? How it ended up is, of the 8 men, 6 were sentenced to death. The leader and the one who dimed everyone out was sentenced to a 30-year prison sentence along with one other. After the war, President Truman commuted both of their sentences and returned them to Germany out quite well compared to their compatriots who they ratted out. So the question is, why are we talking about this case? Why does Ex Parte Quirin even matter in this year, in this time and age? Well, I'll tell you. Because every single generation asks, how much power should the government have during a time of war? And we live in the United States, we're basically always in a time of war. The questions that come up are, should constitutional protection change when national security is at stake? And where do we draw the line between liberty and survival? Those questions didn't end in 1942. Just look at September 11th, 2001. Quirin was cited again. The debate surrounding military commissions at Guantánamo Bay specifically referenced it. Supporters argued it recognized the government's ability to deal with changing dynamics on the battlefield, especially when you don't have lawful enemy combatants. Critics argued that it gave the executive branch way too much power and expanded state power into something way beyond what Ex Parte Quirin had contemplated. Whether you agree or not, it still influences how courts look at enemy combatants today, especially in changing battlefields. Who knows what the next war is? Who knows the next place the United States is going to be starting a war or engaging in a war, or what a war looks like? For instance, with the rise in drone technology, we just don't know, and we don't know how these laws are going to be applied moving forward. That's why it's so incredibly important to look in the past and see how they were applied. There's an important nuance that's often missed that I think we really need to focus on. The Supreme Court did not say that the Constitution disappears during wartime. That is not what Ex Parte Quirin says. But the court did hold that a particular class of defendants during wartime could be held to military tribunals as opposed to the civilian system if caught within the United States. That distinction is exactly why constitutional lawyers debate how broadly or how narrowly Ex Parte Quirin should be read and applied. So why this matters today? Ex Parte Quirin makes us confront an uncomfortable truth. Constitutional law is rarely tested under normal circumstances or normal times. It's tested during moments of crisis, war, terrorism, extreme national emergencies. Those are the moments where governments start to encroach upon civil liberties and start to take more and more power that is very hard to get back. When courts have to decide the limits of those constitutional powers, those answers aren't always obvious. In addition, when those answers are given, the ripple effects in the future and the slippery slope arguments of how it will impact future generations in future circumstances are not fully flushed out. Reasonable people continue to disagree, but understanding these cases helps us understand how American law adapted from the World War II time to today and helps us make predictions about how it might adapt in the future in changing wars, in changing dynamics with changing factors. After all, the American legal system like everything else in life, works great when it's not under pressure. However, when you put anything under pressure, you really have to study and understand where things can go wrong, and in some cases, horribly wrong. So this week, as you hear debates about executive power, which you will, and as you hear debates about military tribunals, which you will, or national security, which you will, or constitutional rights, remember, it was one beach, one submarine, 8 men, 2 locations, 2 states, and one Supreme Court decision from 1942 that continues shaping American law and how we deal with enemy combatants going forward. I'm Brian McCann. Thank you for joining me for This Week in American Legal History. Like, share, and follow for more.